counsel. Welcome to today's video episode and podcast of Legal Scrubs. I've been talking recently about some provisions in employment contracts for doctors that need special attention. You need to look at these when you're entering into, really before you enter into an employment agreement with either a practice or a hospital. And for example, I talked recently about non-compete provisions. Today I want to talk about a different type of provision in an employment contract, and that is a provision that deals with tail insurance and who pays for tail insurance when a doctor leaves the practice or leaves employment under his or her employment agreement. So let's first talk about the two major types of malpractice insurance that doctors have. One is, the two types are claims-made policies and occurrence policies. Claims-made policies simply mean that coverage under the insurance policy is provided for the insured physician if a claim is made by an injured or allegedly injured party during the time that the policy is in effect. So the key time frame for determining if coverage is available is when is the claim made. If the claim is made at a time that the doctor has insurance under the policy, then the policy covers the doctor. If the claim is made at a time after which when the doctor is no longer covered by that policy, for example, if the doctor leaves that employment situation, goes to another practice, maybe in another state, and that old policy is no longer in effect, if a claim is made under what would have been the old policy, but the policy is no longer in effect, then there is no coverage. So that's what happens is sometimes a doctor will leave a practice, the insurance coverage for that doctor is terminated because he's leaving or she's leaving the practice, and then a claim later comes in that pertains to the doctor's work at the old practice, but because the policy is no longer in effect, the claim is made when the policy is not in effect, and so there's no coverage. The other type of policy that doctors have or can have are occurrence type policies, and what that covers is a claim that is made that with respect to an event that occurs during the time that a policy is in effect. So in my other example I just gave, if a doctor leaves a practice, that policy is canceled because the doctor is no longer at that practice, and a claim is made after the doctor leaves, but it pertains to an occurrence that happened while the doctor was employed by that practice and when there was coverage in effect, then even though the policy is no longer in effect because the claim is made based on an occurrence that was at a time when the policy was in effect, there would be coverage. So as you can imagine, occurrence type policies are more expensive generally than claims made policies, and for private practice physicians you more often see claims made policies as opposed to occurrence type policies. So you need to at least be aware of what type of policy that your employer is going to provide for you as an employed physician. If it's a claims made policy, then that means that if you were to leave the practice and that policy were to terminate with respect to you, there's going to be a gap in coverage if you leave the practice and then a claim is made after you leave related to a time when you were still at the old practice. Because if it's a claims made policy and you've left and the policy is no longer in effect, then you don't have coverage, and that's where tail insurance comes in. If your employer is going to be providing a claims made malpractice policy for you, then it's imperative that you have the ability to get a tail coverage policy, or that's what it's called, a tail policy, to cover you in the event that you leave. Who pays for that tail cover? What does tail coverage cover in effect? It covers the tail period, the period of time after your old policy ends until some period that would include the ability to be covered for claims that were made after you've left. And so even though it's a claims-made policy, it extends the coverage by having this tail added on to the policy that's going to protect you if you were to leave. Now, that's what a tail coverage policy is, and that's why you need one if you have a claims-made type malpractice insurance policy. That's going to protect the doctor when he or she leaves the practice. Now, who pays for the tail insurance policy? That is subject to negotiation. And the time to start talking about it and negotiating that with your employer is before you sign your employment contract. Now, typically the employer is going to be in a better position to pay for the tail coverage policy or endorsement than the individual physician, because the group has probably more wherewithal, deeper pockets, more financial resources to be able to pay for that. And in addition, the group practice is going to want to be covered in the future anyway, even if the doctor leaves. So I would say that the starting point for any negotiation for a doctor joining a private practice is to make sure that there's going to be tail coverage provided if he or she leaves the practice. And the first step in negotiating the inclusion of that provision is to negotiate on the basis that the practice, the employer, is going to pay for that tail coverage for the doctor. Now, there may be some pushback on that, particularly if the doctor leaves because of a breach of contract, or there's some kind of dispute between the group and the doctor. All that can be negotiated in the terms of the agreement, but I would say that you want to make sure as a physician that you have in your employment contract a requirement that the group provides for you a tail coverage policy if you leave the practice. And again, your first step in negotiating the inclusion of that provision is to take the position that the group itself should pay for the tail insurance coverage. Okay, I hope that helps. If you have any questions, please feel free to get in touch. I'm Dan Smith at DPS Legal Counsel. Thanks.